Thank you very much, Joel. It's my pleasure to be here to introduce somebody else. First of all, FACT itself has been in existence for somewhere over 15 years now in various forms. And the Children's Rights Council has been around for almost 20. And during that time, both organizations have dealt with many people. The person that I'm going to introduce is somebody who has been a lawyer for a bit longer than that, and was a family law lawyer. And I'd like to say very sincerely that he's a family law lawyer that is unlike any other family law lawyer that I have met in the Toronto area, and one who actually gets it a lot of the time. He is a founder of the Canadian, founding editor of the Canadian Journal of Family Law, and has made some excellent papers that are available on his website, and I would highly recommend that. And he really is a lawyer who both understands family law, understands the damage that it does to children. Of course, he managed to have, what was it, 8 of his own? Seven, sorry. Limited.
3 grandchildren.
And 3 grandchildren, I'm sorry. So, see, he really does get the children's issues in a lot of these things, and it's a real pleasure to be able to introduce Gene Colman. Now, just before I do that, this topic is split between 2 people, Gene Colman, who's immediately to my right, and Carrie Lind, and I'll let Gene do the introductions for Carrie. So thank you very much, and here's Gene.
Thank you very much, Brian. I'm going to be presenting some original research today, and we're very fortunate to have with us Carrie Lindy from Vancouver, a very dedicated family law lawyer who I believe also gets the issues quite correct. I'm just going to say a few words about Carrie, and Carrie will be speaking towards the end of my talk on a matter that will tie right into the things that I'll be talking about. Carrie's been a lawyer for 37 years. His website is divorceformen.com. He's been a shared parenting advocate for 18 years, and about 15% of his caseload consists of moms as well. Where justice needs to be done, that's where you'll find Carrie. He's worked with the late Richard Gardner on several cases, and with the RANs, so he's very well plugged into parental alienation and what is going on in that respect. And I feel very honored that Carrie has agreed to help out with this presentation. I'm speaking on a trends analysis. It's going to focus to some extent on the research that I have done. In case you can't read it, the lady is saying here. There it is. There he is, the man once known as your father, but now infamous throughout the universe as Gordon, divorcer of wife. And of course, parents that are the subject of parental alienation face that sort of sentiment all the time. And then the question arises, what can we do as professionals to try to ameliorate the situation? And what can a court do? So some of the topics that I'll be touching on in this talk will reflect the questions up on the screen now. What are the trends in the Canadian case law since 1987? I took 87 because that was the first case that really came to grips with parental alienation and seemed to recognize that it existed. I asked myself whether mothers and fathers were treated the same. And during the last few years, is there a tendency to treat this issue more severely with more definitive action? And in that respect, Carrie Lindy will be talking at the end of my presentation about a decision that he and Jessica Coe, his junior counsel, and Jessica's also here in the audience, a case that they were privileged to work on, which I believe will be a very important precedent. I simply like the picture of the Milton Courthouse. Now, Let me tell you where we'll be heading here. I'm going to have just an overview of some of the legal remedies that we can apply in parental alienation cases. I will explain how I conducted my research. We'll look at some of the demographics involved as discovered in my research by way of gender and province. We'll look at residence, changing residence. That's, of course, the supreme remedy in parental alienation. And I asked myself, are there any differences whether the alienator is the mom or the dad? If residence is changed, how the courts address access to the alienator? And were there any differences in terms of whether the alienator was dad or mom in that respect? What about counseling? How frequently did the courts order counseling? Were the courts order just the children, the target parent, the alienator? What are the courts doing in that respect? And I found some surprising things about the appeal cases, so stay tuned. And then I'll be talking about contempt a little bit. I'll conclude with some of my general impressions, and then I'll turn the platform over to Carrie. When I started practicing law and well into the 80s, we lawyers were told by those up on at this podium, by judges, by social scientists, by psychologists, don't worry. Time heals all wounds. The child will get over it. He'll come, he'll visit, da-da-da-da-da-da. But accept alienation. Time does not heal alienation. Dr. Gardner told us that. Dr. Warshak has told us that. And we need fast action. So when we're looking at legal remedies, most effective remedy, of course, is to change the residence. And another remedy we can have is we can restrain the contact between the alienator and with the child and the target parent, which we call in Ontario a non-harassment order. We can restrict the access in such a way, make it supervised access if there is to be access. We can have the target parent retaining the important documents, passports, birth certificates, etc. We can monitor the telephone and mail contact. We can make a finding of contempt against the alienator. We can make sure that there's counseling to parents and children. A very effective remedy in the last number of cases in Ontario and elsewhere is that the trial judge can retain jurisdiction over the case. The earlier thinking was the trial judge is finished, that's it, you're called functus in Latin. A lawyer have to bring in a Latin word, of course. But now judges are retaining jurisdiction. Say, we'll see you back here in 6 months. I want a report from all the professionals involved. I want to see how things are going. And we can, if we're not changing residency, we can increase the number of visits to the target parent is another remedy. Of course, there's the family workshop run by Dr. Randy Rand and his wife. It's very expensive, as many of you know. But we can have the alienated order to pay all those costs, including the traveling costs. Again, out of the financial reach of most people. Now, there are two excellent cases that I would heartily recommend that if you're interested in this area, no matter what, if you're a layperson, psychologist, lawyer, that you look up. And that's the decision of Justice Turnbull, released on 22nd of April 2008, and a very recent decision of Madam Justice McWatt, released 16th of January 2009. And the latter case contains a very good listing of the characteristics of parental alienation from the point of view of what do we observe in the alienator, what do we observe in the behavior of the children. And I hope that this latter case of Justice McWatt will serve as a checklist for the courts so that parties will not have to bring large numbers of experts to explain the phenomenon to the judge and to prove that it's taking place. Maybe that's just a pipe dream, but we have to be concerned about the costs to the families in these situations. So I asked myself, how do we measure what's going on in terms of parental alienation in Canada? And what I did with the assistance of my law clerk, Chris Wright, who is here today, and a number of previous students that have worked for me over various times over the last year, is we took all the Canadian cases and the two main online databases that lawyers use. And we looked for all cases where the court made a finding that parental alienation existed. We categorized and characterized the factual findings and orders made in each case along the following axes. We looked to see if the alienator was mom or dad. We looked at the remedies that the court awarded. We looked for the various indications of parental alienation. We, of course, looked at the children, the number of children, the age and sex. Come on, let's go. There we go. Reasons for certain remedies given, whether the order was interim or final, and the province. I'm not going to speak about all those topics today. I'm just telling you what we did, and what I ended up with was a Excel spreadsheet, which would actually, I brought it to a previous presentation that I made to a more private grouping than this one, and it just spread out across the whole wall when I printed it up. But that's how I kept track of the data. So let's start with the demographics. My colleague, whom I respect greatly, Jeffrey Wilson, editor of the Ontario Family Law Reform Reporter, author of Children in the Law, he posed a question in a recent continuing legal education program, whether PA is a gender-based condition. And I'm quoting from his paper presenting at that recent conference. Jeffrey stated, "There are no studies that suggest it is gender-based. Jurisprudence does not suggest a greater sampling in one gender than the other." Now, we're aware that the late Dr. Gardner wrote that this was parental alienation was primarily a mom phenomenon, though not exclusively. So I was wondering, what could we prove in terms of the demographics? What could we find in terms of the demographics? I didn't know what I would find. My sample consisted of 74 cases where the court recognized that parental alienation was going on in this particular case. Now, if the court discussed parental alienation and said, this is not a case of parental alienation, that case did not make it into my database. I found that in the Canadian cases since 1987, 50 of them, mom was the alienator. 24 of them, dad was the alienator. Then the breakdown was mostly in Ontario, 28, BC with 13, Alberta with 11, a few other cases out west, one case from Newfoundland, no cases from PEI, no cases from any of the 3 territories. Then what I did was, again, with the help of Chris Wright, my clerk, and other students, we gathered the data together. We tried to keep mom as pink, dad as blue, and we tried to analyze the figures that I just gave to you. But this is hard to read, so let me try and break it down for you, for those of you that like words better than charts. And this is also another chart, but we'll go further. Was there any difference, we asked, in how the courts have treated moms and dads when the court invoked the ultimate remedy of changing a child's residence? And we found a number of interesting things. Here, so we took the data, we broke it down into the number of times residence was changed, and where it was changed with the mom and where it's changed with the dad. And in terms of the gender differences, we found that there's a marginal significance level in terms of applying the chi-square test, which is a standard test for determining if you've actually uncovered anything. was at the 14% level. You like to have a 5% level to have statistical significance. Part of the problem was that our sample was relatively small, being 74 cases. But let's put it in words now. Again, there were 74 cases dealing with parental alienation. Of those 74 cases, the court changed residence of the child in 50 of them. That is 67.6% of all PA cases. The mother was the alienator, as I said, in 50 of those cases, and the dad in 24. Of the 50 mother alienator cases, the courts changed residence to the father target parent in 31 of those cases, 62%. Of the father alienator cases, the courts changed residence to the mom in 19 of them. That is 79.2%. So it would seem that if you're the dad, you have a greater probability, looking at all the cases, of having residence changed on you. But again, the statistical significance of that was only at the 14% level for the scientists among you. Then what we did is we broke it down according to year. And I asked myself, well, what are the trends here? Is there anything different happening, whether you take the earlier cases from 87 to 2000 or the later cases from 01 to 09? And I said 09, that would be to January 30th, 09 was the cutoff date. And I found that there were 21 cases in total from 1987 to 2000. That's some, 13 years. From 01 to January 30th, 09, about 8 years or so, there were 53 cases. So we certainly see a trend that there are many more cases of parental alienation appearing in the law reports in the more recent years. And this is the same data, just reflected in a bar chart. I'll just skip that. Now, of the 53 cases dealing with alienation from January 1, we found that the courts changed residence of all of the child in 39 of them. So we're up a little bit, 73.6%. The mother was the alienator in 35 of those cases, and the dad was the alienator in 18 of those cases. Now, of the 35 mother alienator cases, the courts changed residence to the father target parent in 25 of them. That's 71.4%. And of the last 12 mother alienator cases in 2008, just looking more recently, plus the one case in January of 09, the court changed residence in 7 of those 12 cases, a lower amount, 58.3%. We see a curious drop there, but again, the sample sizes are small. So we looked at the 18 father alienator cases more recently from 01, and we found that the courts changed residence to the mom, target parent, in 14 of them, 77.8%. And we looked at the last 4 cases that occurred during 08, the court changed residence in 3 of them. These are small samples, but you see the percentages are higher in the case of dads. How much weight we can put on that, I'm hesitant to say, but that's just what the numbers give us. Now, mother alienators have had residence changed, as you know now, 25 out of 35 times for 71.4%. Father alienators have had residence changed 77.8% of the time. The percentage spread is so small over a small sample size, and therefore, while it may appear that moms are dealt with more leniently, in fact, the significance of the difference is not statistically significant at all. It comes out to numbers that we would say are not statistically significant. But the percentages are there, and you can make of them what you will. Now, during the earlier time period, from 87 to 2000, the difference between mom alienator and dad alienator with respect to residence change was significant, however, at the 7.2% level. And during the later period, the difference, as I pointed out, between mom and dad alienators was not statistically significant at all. So, what is the implication of all this? Mother alienators in the last few years seem to be dealt with slightly more leniently. Again, I'm giving cautions about statistical significance here, but they seem to be dealt with slightly more leniently. They lose residence 71.4% of the time, while dads lose residence 77.8% of the time. The numbers don't have statistical significance. It would appear that at least since '01, the alienator, no matter what gender, and I think that's important, because we expect genders to be dealt with the same in the court. The court should decide cases based on the facts of the case. But then it would appear that no matter what the gender, we have a reasonably good chance in the recent cases of the alienator losing residence, and that's a 73.6% chance. And those odds, I would say, are pretty good. Okay, come on, let's go here. There, that's what I just said there. Sorry, didn't have it up. So the other measures when we're changing residence that we can use, that we have at in our toolbox, so to speak, are the RAND program. Again, very expensive. But no contact by alienator, that's an easy order to make, and Kerry will be mentioning that from the case that he and his junior counsel just completed. We can have a police assistance order to implement the order. Again, that doesn't cost too much. We can have a non-molestation and non-molestation, non-harassment order. We can use contempt, which can be effective, and of course counseling is, I would say, a prerequisite, but I'll have some surprising data on counseling coming up. But where residence was changed to the target parent, have the courts dealt with the issue of access to the alienating parent in the same fashion, no matter what the gender of the alienator? One, I would have expected similar results. Did I find that? It's hard probably to read from where you are, and I'll be going over these figures, but I'm just showing you what I did here. So I looked at the issue of access being granted or denied to the alienator parent in those cases where we did change the residence. And I broke it down according to province, et cetera, and then of course according to gender. There were 74 cases dealing with parental alienation. You all know that by now, 74 cases. We know that the mother was the alienator in 50 of the 74 and dad in 24. Of those 50 mother alienator cases, the courts changed residence to the father target parent in 31 of them. You know that already. Now, of those 31 cases, the court granted access to the mother alienator in 26 of them. That's 83.9%. And denied access to the mother alienator in only 5 of those 31 cases. Now, of the 24 father alienator cases, the courts changed residence to the mother target parent in 19 of those 24 cases. That's 79.2%. Of those 19 cases, the courts granted access to the father alienator in 12 cases, that's much lower, 63.2%, and denied access to the father alienator in 7 of those 19 cases, 36.8%, a higher percentage than the 16.1% corresponding with mom. So we see a discrepancy between the genders here. And when we analyze these data, as I've done according to gender, we do find a significance level of 10%, which isn't too bad in terms of there being significance there, which according to the percentages, according to running the chi-square test, it would seem that there is some statistical significance here. Just reflecting the data in a chart form there. And then I turned to the issue of the frequency of court-ordered counseling. And you see here that counseling was ordered. If you look at the white portion underneath, a number of lines down, 25 out of 74, 33.8%. So that chart we had up, I analyzed it and put it out here. You all know about 74 cases, the breakdown of 50 and 24. Now, of the 50 mother alienator cases, the courts ordered counseling in only 12 cases. And when I say counseling, I mean any counseling at all in this case. Of the 24 father alienator cases, the courts ordered counseling in 13 of those, 54.2%. That's more than double. Combining them all, you have 33.8%. Again, it's a very low figure. So I took these figures and I put them on this chart and I sent them off to my professor friend at U of T to run the chi-square on this, and it came out to be very significant at the 1% level. And the social scientists will tell you, I understand, that that is a high level of statistical significance in terms of the differential treatment by according to gender. It would appear that the likelihood of any counseling being ordered is higher where we have a father alienator situation. The statistical significance here is quite high. It is surprising that counseling is not ordered more frequently. This was one of the most surprising results of my study. Some case law says you can't order the alienator into counseling. Some judges have done it, some haven't. But the data that I've just been presenting to you, we got a positive on counseling if anyone was ordered into counseling, not just the alienator. So I want to emphasize that point. Counseling, historically, over all the cases, the 74 of them since 1987, has not been that high. Then I did look at the situation of how did the courts deal with the alienator in terms of ordering the alienator into counseling. So where the mother was the alienator, she was ordered into some form of counseling on 7 of the 50 occasions, or 14%. Where the father was the alienator, you all know now, 24 cases, he was ordered into counseling on 7 of those cases, 29.2%, a higher percentage level. Again, I put all this into a chart, sent it off to my professor colleague, and it came back at a marginally significant level at 12%. So we have some statistical significance to this. And then we just put it into a what are these called? This chart form. And one can see, you see graphically the differences between the genders here. Well, I thought, well, what are the trends? Okay, because my 54 cases go back to 1987. It was the first case. So I looked at 2007, I looked at 2008. And in 2007, there were 16 cases in my database in that year. And I was very surprised because counseling was ordered in only 4 of them. I thought, that doesn't seem right, but that's what it was. Only 4 of them, and only 1 of those cases involved the parents. But not to despair. Let's come to 2008. We have 16 cases in 2008, plus the 1 decision of Justice McWatt in January '09. And the court ordered counseling in 9 of those 16 cases. So within those 9 cases, the alienator was ordered into counseling in 4 of them, and it was suggested that counseling be undertaken in 2 additional ones. So you've got 6 of the 9 with a tendency towards counseling in the more recent cases, and that is very encouraging. So I said here that I don't think the slide here is actually accurate. I should say more recently than in more recent years, because in 07 it was very low. But I think that the tendency now in 08 is certainly to involve the mental health professionals in counseling. So things are looking up. Now I found an anomaly in the cases. There were 5 appeal cases, and the fathers did very well. As someone practicing in the courts here in this province for 30 years as a lawyer, and before that worked Osgoode Hall Legal Aid Clinic from my 2nd year law school, sort of had the impression that fathers tend to do a little bit less well than moms in courts generally. Understatement. And they're having other people wiser than me who have written on this and have noted this. There were 5 appeal cases dealing with parental alienation. Of those 5 cases, 2 overturned the order of the trial judge. And I list those cases here, but I'm not going to take time on it. There's 2 cases, they succeeded there. In the remaining 3 appeal cases where mother was the alienator, the appeals were dismissed, confirming the previous orders. And then I have the cites for those cases. I should just actually go back here, if I can. There. This bottom case there is AA versus SNA in the British Columbia Court of Appeal. It came back to court because mom wasn't abiding by the directions of the trial judge, and that's Kerry's case, which he'll be talking about, AA versus SNA. So we have 5 appeal cases, and the dads won all 5 of them. And I don't know what to make of that, but it was unusual, so I presented it. I said that contempt can be an effective remedy, and I gathered together some of those contempt cases. So when this appears on my website or this conference's website, then the references with the legal citations are there. So what are my overall impressions? Well, there are many more mother alienator cases in Canada, 50 versus 24. I'm not trying to dump on moms. I'm just saying that's what the data revealed. And it is consistent with what Dr. Gardner perceived just from his experience. There is a tendency to change residence more frequently when the father is the alienator, 79.2% versus 62.0%. However, as I've admitted, the differential is not particularly statistically significant. But that being said, the trend is there. And what I think we need to learn here is, now that I've pointed this out, and I will be preparing a paper, a more formal paper of publication with footnotes, etc., on my research, is that we have to be, as lawyers and judges, vigilant to make sure that we judge the cases, that we deal with the cases, not that court is the best way for dealing with these things. Of course, you have no choice in many cases. I'm sure at this conference we'll be talking about other modalities of dealing with parental alienation, but if you're in court, you have to judge the case that is before you, and you should not be influenced whether the mom is the alienator or the dad is the alienator. You have to take action, and there should be no differential really in how either gender is dealt with, because kids suffer from parental alienation, and we must take those steps that need to be taken and not be influenced by the gender of the alienator. So another impression here we have is where mom is the alienator, she obtains some access more frequently than does a father. 83.9% versus 63.2%. Statistical significance level is middling at 10%, but nonetheless we seem to have that trend in the case law. That raises the question of whether, under what circumstances is it beneficial to the child to order access by the alienator parent. The theories tell us, certainly initially, what you have to do is remove the influence of the alienator entirely. I was involved on a case, still involved on a case, but last year it came up on an interim level, and the Justice Wildman in that case intervened at an interim motion that took place after the abduction, excuse me, I don't want to use inflammatory terms, after the alienator dad removed the children from the home without consent of the target mom. And Justice Wildman stepped in and said, well, dad has had the kids exclusively with mom now for 5 or so weeks, exclusively with dad, excuse me, for 5 or more weeks. The children are now going to be exclusively with mom for 5 or more weeks. And when we finally had an assessment done, the assessor appeared to agree with that and felt that that gave mom an opportunity at an early stage to undo some of the alienation that had been perpetrated by dad. So that brought home the point to me that early intervention, perhaps with no access to the alienator, is good. But I'm sure we all believe that all things being equal, children are entitled to a decent relationship with both parents. And the goal of the lawyers and the mental health professionals must be to find ways of keeping the children in contact with both parents where at all possible. And I commend Justice Wildman for her decision in that case. And now, of course, the kids are seeing dad. There are problems there, but that's specific to that case. So counseling is being employed more frequently in the very later cases in 08 and into the first one in 09. But even the alienator is being ordered into counseling despite some case law that denies the judge the power to do so. And of course I applaud that tendency, the tendency of ordering to counseling. I disagree with the case law that says the judge doesn't have the power to do it. The last 2 cases that I referred to, the of Justice McWatt and Justice Turnbull, provided for counseling to all concerned. And those are the last 2 very strong cases in Ontario, and I agree with them. They're right, and I hope that case law that says you can't order the alienator into counseling, I hope that case law is dead. The father alienator cases appear to attract statistically significantly more counseling orders than do mother alienator cases. You can see where I'm trending. Counseling is needed in these cases, no matter what the gender, and I hope that difference will disappear as the case law develops further. As I've mentioned, somewhat inexplicably, you have 5 appeal cases where the guys won in all 5 of them. And contempt can be an effective remedy to set up a future residence change and bring accountability to an ungovernable parent. What you will find in the cases where residence is changed, you'll find the number of incidents, and I haven't quantified it as yet in my research, but you'll find previous contempt motions where the alienator was found in contempt and where he or she was warned in no uncertain terms, if you carry on the way you were carrying on, you're going to lose your children. I'm finding you in contempt here. And so you have those contempt findings. It helps. And you'll see in at least one of the, I think it's Justice McWatt, which one is either Justice McWatt, Justice Turnbull's decision, they talk about the previous contempt, the judges talk about previous contempt findings. In the decision of Justice McWatt, there was contempt motions that were tied in with the trial, and the decision on that, I understand, is going to be released in the next few days. And from reading the decision that she released with respect to switching custody, I don't have too much doubt but that the alienator is going to be found in contempt in that case. The courts of Canada are increasingly taking more drastic measures to ameliorate the effects of parental alienation, from changing residence to counseling for all concerned, to making contempt findings, to supporting the RAND program. The tendency is in favor of proactively addressing the problem. At this point, I'm going to turn the program over to my colleague Carrie Lindy, who's going to talk about the AA versus SNA case released on Monday. He's going to tell you about the importance of the court standing behind its orders and providing for effective enforcement, and the key importance, something that I haven't touched on too much in this talk, of one judge managing these high conflict cases. Carrie.
Thank you. I've spent, ever since my first midlife crisis, which was when I was very young, with one foot in the roots camp and more recently the other foot in the rights camp. They are two very distinct areas of my life. I often quip that roots people have a pretty good understanding of rights people, and rights people have less of an understanding, usually, of roots people. I find as I get older, I need more and more time with the roots people, the Jungians, Robert Bly, that whole organization of people who are marvelous, spiritual, to give me the energy to keep going in the rights camp. I wanted to I was at I forget the year, but it was in Seattle with Robert Bly and John Lee and a lot of the groovy roots people, mostly middle-aged people. And a 19-year-old boy from Boston was there, and near the end of it, he was involved in a lot of the stuff. He mentioned that he came out and he was staying with his father, who he hadn't seen in a decade or more. And he came in near the end, and he said that last night was really interesting. He said, my father went up to the attic and got his guitar, and we had some beers, and I got up the gumption to tell my father that, you know, Dad, I never really ever did believe all those things that my mother said about you. And he said that his father wept and said, now I can die. This is not anywhere near analogous or close to it, but looking out at you all and seeing this symposium, I have a sense of now, you probably wouldn't want to hear this, now some of us can back away and leave it. I'm not going to, but it's up and running, clearly. I want to give credit to two people without whose work we would be unlikely to be here. Richard Gardner has been mentioned, and the other radical mover and groover and all this was Phil Cook, who died recently, retired aerospace marketing man who decided that he could market shared parenting, set out to do it, and way back when did it in California with great success and went all around the place doing that for the rest of his life. This case that I'm going to talk about, I suspect that in this case the alienating mother will probably end up in jail if everybody's prognostications of this phenomenon are correct. It started out, and I'm going to give you the closest I can to the sites where you can find these cases. I won't give you the whole site because it's humongous. We'll get confused. But you start with www.courts.bc.ca. I'll repeat that. www.courts.gov.bc.ca, and you go there and you can find the reported cases. I'm sure everybody has it in the Supreme Court and the Court of Appeal. This particular case is AA versus S&A. SNA, AA versus SNA. There is a order of the Court of Appeal of British Columbia that nobody do anything that can even remotely suggest who these people are. But the trial decision is from Mr. Justice Preston, Preston, in 2007, so you just put that in and you will get that. The Court of Appeal decision is also 2007. And the recent judgment of a Chambers judge, Martinson, is also there, but 2009. The simple facts are that the trial judge found as fact that the mother was an extremely ardent psychopathic alienator. Her brother took the stand in her case, but admitted under cross-examination that yes, she had put out a contract for the life of my client. And a variety of things. It was just amazing. I want to make a point here, though, that I think that we should all be careful not to think that these solutions, which I'm going to suggest Martinson did, are only good in extreme cases. It's unfortunate that it takes such an extreme case to get the ball rolling, but then it's got to be broadly applied, I would argue. The trial judge said that it's clearly in the child's best interest to go live with the father. And then, as lawyers wait for, and you see it on TV, however, the word that you cringe at comes down, if I did that, this young girl would probably run away. She probably would end up having a dysfunctional relationship with her mother, blah, 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 blah. And so, therefore, I'm going to award sole custody to the mother. The Court of Appeal had a very easy job to do. The best thing about the frankness and honesty of Mr. Justice Preston was that he went on record as saying the best interest of the child would be with the father, and the Court of Appeal basically said that's the end of it. Custody of the father. 3 hours a month, supervised access to mom. That's when I was not involved in the case either at the trial or the Court of Appeal, although I was involved with the father on the side, curiously because the child has citizenship in another country, and he had the local consulate for that country in Vancouver on side and arguing with the embassy in Ottawa that they should appoint me as an advocate for the child. Unfortunately, it never happened. It would have been interesting. So I followed it all the way through. I got involved to deal with all of the loose ends, and there were several. The psychologist and the therapist, a play therapist, whom I have previously taken to task in exactly the manner that our first speaker did, let them play in their own sandbox, but leave the rest of us alone. If anybody's interested, I had Richard Gardner give me an expert report on the reasons why you shouldn't let a place therapist anywhere near a custody, kids that are involved in a custody dispute. But So the 3 hours a month, the child was doing better than this and better than that and was thriving, blah, blah. And then every time it came back from 3 hours with mom, even though supervised, not a particularly adroit supervisor, regression every single time. The child was not developing in the psychological side, and we brought an application last fall to suspend access to the mother completely for 1 year. And Jessica Coe of my office took that motion, and what happened was that we were successful. And I just want to read you some of the things that came out, which is what Jean's asked me to talk about. Not only did she was ordered not to have any dealings directly or indirectly, either her or her mother, who is the grandmother, was denied any access right off the bat from the Court of Appeal. I told the Madam Justice Martinson in the first appearance I had before that her work was probably the most difficult work yet to be done. She's an adroit, experienced, because I have to appear before them all, I can't say she's the best judge, but she's certainly one of the best family law judges. And she came down with her judgment with a lot of stuff, which clearly makes me understand that she knows the subject and read it well. She talks about in the judgment that she's saying that, for instance, the mother may not bring any further applications before the court without first having it cleared and okayed by her. She seized herself of the matter. So she did that. She talks in paragraph 77 about the importance of the court involving itself much more seriously at the very beginning of these cases, which is laudable but very difficult, in my experience, to get any judge to, from the get-go, to see it that way. The first thing we do out in BC is we have what's called a judicial case conference, where everybody appears in front of the judge. And as I mentioned last night at the dinner, these judges start right off, no matter what, looking down and saying to Mom and Dad, you're both very reasonable parents, and I'm sure neither one of you has anything bad to say to the other, and we're here to resolve this and touchy-feely, and let's all go home. And it's so difficult to politely tell a judge that, you know, if 2% of cases get that far in British Columbia, that means one of the parties is totally wacko. And then talk about, you know, you guys have got communication problems. Both of you have got this and got that. It's very difficult without the judge saying, oh, you're being litigious. Other lawyers says, oh, Mr. Linda, we don't want to go down that road. And they all get sucked into that side of it. I had a trial a few years ago where I acted for a mother. It was a 6-week trial on this whole thing. Deirdre Rand was my expert on that one. And I managed to slip in for the judge to read some of Richard's works. It wasn't admitted as evidence, but the judge had read it and made some comment with a ha, 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 looking at it and said, oh, I see here that he thinks even judges contribute to the problem. You know, and gave everything to the father. And the father's wife was a nurse in the maternity ward who couldn't have kids, so the two of them hijacked these 2 teenage girls. When asked why they didn't want to live with their mother, we don't like the way she dresses. Sometimes she gets a bit overweight. You know, the classic frivolous stuff. But to go back to the point, the judgment goes on at some length as to why it's very important to have one judge. She comments that she is the 5th judge post-Court of Appeal to have dealt with this. The previous judges love to shuffle it off. Well, you know, we've only got, let's see, this is a 2 hour, I got an hour. I'm afraid, well, you know, blah, blah. And then we've gone halfway into it, and we say, would you please seize yourself? No, I don't think there's any necessity for it. They don't want to have anything to do with it. So she did that, and she talks about how it saves costs and this and that. And the other aspect that she talks about is the need for the courts to deal up front much more vigorously with these cases. to be more of what I'm suggesting in the judicial case conference, that you, from the get-go, you look and see where's the psychopathology here and get on it. And you can read all of that. I won't go through it. It's all in the judgment. She does some very good quoting of some works that you may or may not be familiar with. She talks about Justice David Aston in this province, wrote an article, High Conflict Families, a Sampling of Ideas and Strategies for Judges. That paper was presented to the National Judicial Institute, High Conflict, in 2006, unpublished. Talks about case management as being critical. Professor Bala, Barbara Fiedler, Dan Goldberg, Claire Houston, Alienated Children and Parental Separation, Legal Responses, and some others. Phil Epstein and Lenny Madsen in the Family Law Newsletter of, doesn't give a date. Yes, she does. Well, it's Epstein and Madsen this week in Family Law, June 17, 2008, and they comment on one of the case that Jean just talked about. And she talks about another case here, the L bracket AG versus D bracket KB from this jurisdiction, where the judge says it took almost 14 years for the issue to be resolved in this case. Finally, I left it in my hotel room, but I printed off I've been working on a case for 10 years. We've completely lost a 16-year-old who's off into drugs and sex and booze and drinks and running away. And we're dealing with a 14-year-old son we're trying to salvage from the mother. This is a very interesting case because my client's mother died and left a huge estate to these kids when they turned 35. And the mom has basically alienating these kids as best she can to her way, so she got a piece of the action, right? She wants some of that money when the time comes. And the result is she lets these two kids do whatever they want. And we were in front of a particular judge in BC 10 years ago who threatened the mother, if you do this one more time and you come before me, I'm going to do it. So 6 times later, it's still, if you do this one more time, blah, blah. And nothing ever happened. We lost the one. I had 9 typed pages. I think there's been 47 applications before the courts. And ironically, 2 weeks ago, when we were trying to get this thing set for trial, it's going to come off in August, we got back in front of the same justice, who diddle-daddled 10 years ago. And my client told me afterwards, you know, I sent that judge a real ass-ripping letter. And I'm glad I heard it afterwards. But anyway, he didn't want anything to do with it, blah, blah, blah. So that's still pending. So those are the comments I make. And to re-emphasize this particular decision, I think maybe, I don't know, I stand to be corrected, but I'm unaware, and I don't know, I think Jean and I tried to figure it out. If 1 year total access denial is the longest period, and as I say, this mother, I have full expectation. If she appeals it, Jessica and I talk about how at least she's going to stay above ground. If she doesn't appeal it, she'll do something, that she always did, and I suspect we'll be back asking to put her in jail, which is a horrible thing to have to do to any person. But maybe that's where it comes to. I hate to think about that. Thank you.
I want to again thank Gene C. Colman for being here and for his very in-depth research in cases of parental alienation syndrome. And thanks also to Carrie Lynn for being here today as well. Please join me in giving them another round of applause.